welcome to Tarun IS. Today we will be discussing current affairs of 15th of October 2022. So let's start with first news of the day. The first news talks about that how the IRDAI, which is Insurance Regulatory and Development Authority of India, has proposed certain changes and proposed the condition for the private equity funds. When we speak of the equity, we are basically talking about the shareholding. Alright, in insurance companies, in its draft on registration of Indian Insurance Companies Regulations 2022. So let's see what are the changes or what are the conditions that IRDAI has proposed when it comes to private equity fund. The first thing is this, that IRDA has said that the equity funds will be allowed to invest in any insurer in the capacity as a promoter if it has completed 10 years of operation and raised by private equity fund, including its group entity, is 500 million or more. Alright, the second condition that IRDA has put up for the private equity funds is that the investable fund which is available within the private equity fund, it should not be less than $100 million. Now recently, in the year 2020, the government of India had increased the foreign direct investment limit in insurance sector from 49% to 74% under the automatic route. And IRDA in the year 2017 had given the principal approval to the private equity funds to invest in India. Now let's look at the other condition which IRDA has put up. The first is that the investment should not be less than the 25% of the paid up equity capital of the insurer. The minimum shareholdings of the promoter should be maintained at above 50% of the paid up equity capital of the insurer. The insurer may dilute its stake, but it may dilute its stake below 50%, but it should not be below 26%. It also speaks of that majority of the members in the company, like chief executive officer, the managing director, and the key management person and the chairpersons in the board, they should be resident of India. And it also speaks of the presence of the independent directors. Alright, now let's see briefly what Insurance Regulatory and Development Authority of India is. IRDA basically is the apex body which regulates the insurance sector in your insurance industry in India. It was established by an act of parliament, which is Insurance Regulatory and Development Authority Act of 1999. Therefore it is a statutory body, and its headquarters is in Telangana, and prior to 2001 it was headquartered in New Delhi, and after that its headquarters has been shifted to Telangana, Hyderabad. IRDA function, the primary function of the IRDA is to protect the right of the policyholder, is to register the insurance company, and basically it also engages in the renewal, modification, cancellation of this registration, and also creates the regulations to protect the policyholders' interest in India. And the mission of the IRDA is to protect the interest of the policyholders, regulate, promote, ensure orderly growth of insurance industry for the matters connected therewith or the incidental thereto. So this is what we saw about the Insurance Regulatory and Development Authority of India. Now let's move on to the second news of the day. The second news is about that how the GSLV MkIII is to foray into commercial business. Now so far it was the PSLV which was into the commercial launches. However, now onwards the GSLV is to make commercial launches also. It was in news because it is going to launch 36 satellites on October 23. Now we'll talk a little briefly about the GSLV MkIII. GSLV Mark III is the same launching vehicle which carried Chandrayaan 2 mission, and it will be its maiden commercial launch. That means it is the first time that GSLV Mark III is being used for the commercial launching. And so far we know that PSLV, which is also known as the working horse of the ISRO, was used to launch the commercial satellites. Now, in yesterday's current affairs, we discussed about the PSLV, but in today's current affairs, we will be talking about the GSLV Mark III. Now, this Mark III is the now this Mark III is basically the configuration of the launching vehicle. Now, let's speak about the specification of the GSLV Mark III. The first point is that it has the higher thrust than the Polar Satellite Launch Vehicle, which is the most successful launch vehicle of the ISRO. And the objectives of developing Mark III, the first is to launch the heavy commercial satellite, and second, to launch the multi-purpose satellites to have future interplanetary exploration, for example, the Gaganyaan mission, to launch future crewed mission, that is to carry human to space. So we were talking about the specifications of GSLV. Now let's look at the payload capacity that GSLV can undertake. The first that it can carry to different orbits. The first is the geotransfer orbit, and it can carry satellites weighing up to 4 tons to geosynchronous transfer orbit, and it can also carry the satellites weighing 10 tons to lower Earth orbit at an altitude of 600 kilometers. Now, if we look at the engines and boosters of the GSLV, now if we consider the previous year questions, then then question related to this was asked in previous year in prelims exam. So therefore, a few of the important specification of GSLV Mark III becomes important. That it has two Vikas engines, which forms the core stage of the rocket, and it's not important to remember that who has developed this core stage. Just remember that it has two Vikas engines as a core stage. It has got two solid boosters, which are used in GSLV Mark III to give it thrust, and there is an upper cryogenic stage which is known as C25, and this cryogenic engine, they're very complex technology, and they have been developed by only few countries, and India is one of them. Now, this is how the GSLV Mark III looks like. That it has payload capacity to transfer satellite to geotransfer orbit of 4,000 kilograms. Payload capacity that it can deliver to lower Earth orbit is 8,000 kilograms. It has got upper cryogenic stage, solid rock boosters, and liquid stage, which forms the core stage. Now, this is the comparison which is given of the satellite launch vehicle that India has developed so far. The small satellite launch vehicle, the augmented satellite launch vehicle, polar satellite launch vehicle, geosynchronous launch vehicle, GSLV Mark II configuration, and GSLV Mark III configuration. It was developed so as to transfer the heavy commercial satellites, communication satellites, etc. The third news of the day is about the National Green Tribunal had slapped rupees 5 crore fine on Karnataka government for failing to protect the Bengaluru link. So this brings to light the National Green Tribunal. Let's talk about the National Green Tribunal. Basically, NGT, it is a specialized body, and it is a statutory body as it was formed by an act of parliament called National Green Tribunal Act 2010, so as to effectively and expeditiously dispose the cases which are related to the environmental protection and conservation of the forest. India, after establishing NGT, became the third country in the world to form a specialized environmental tribunal, only after Australia and New Zealand. And NGT is mandated to dispose the application or appeals within 6 months, and it has 5 places of its sitting, with Delhi as the principal place and regional offices in Bhopal, Pune, Kolkata, Chennai. Now, what are the powers and the jurisdiction of NGT? Now, the tribunal, it has jurisdiction over all the civil cases which substantially involve the questions related to the environment, and entity is endowed with the power to suo motu take up the environmental issues. It is a statutory educatory body just like courts, and apart from the original jurisdiction, it also has the appellate jurisdiction. It is not bound by the procedure which is laid by the Civil Procedure Code of Civil Procedure 1900, and it works and is guided by the principle of the natural justice. And while passing an order, the entity follows the principle of polluter pays. That means the one who pollutes will be liable to pay. An order of an entity can provide relief and compensation. It can also provide for the restitution of the property, damaged property, and it can also provide for the restitution of the environment. The tribunal's decision, award, or order is executable as a decree of civil court. That means the entity has power of a civil court. It also provides the procedure for the penalty for non-compliance, and there is an imprisonment of 3 years. The fine can be extended to 10 crores of rupees, and there can be penalties such as both fine and imprisonment. An appeal against the order, decision, and award of the NGT it lies to the Supreme Court, and it is generally within the 90 days from the day of the communication. That means this is the from the day of the order that was passed by NGT within 90 days. Order, that means within 90 days it can be appealed to Supreme Court. All right. Now Supreme Court said one thing, that the role of NGT is not simply educatory in nature. It has to perform equal vital roles which that are preventive, ameliorative, and remedial in nature. That means it is not just an educatory body. Its role extends to other dimensions of the environmental conservation and protection as well. Now, according to the NGT Act, it acts under 7 laws. That means NGT has the power under these 7 laws when it comes to the environmental protection and conservation. It is Water Act, Water Cess Act, the Forest Act, the Air Prevention Control of Pollution Act, the Environmental Protection Act, the Public Liability Insurance Act, and the Biological Diversity Act of 2022. Now, any violation pertaining to these laws or any decision which is taken by the government under these laws can be challenged before the NGT. Let's move on to the fourth news of the day. The fourth news is that the Supreme Court has rejected the plea to restrain CCI, which is Competition Commission of India, from investigating WhatsApp privacy policy. So this brings us to the Competition Commission of India, and we will talk about the composition of CCI, the roles and functions of CCI. The first important thing that is to be known about CCI is that it is a statutory body, and it was formed by the Government of India under the Competition Act of 2002. It functions under the Raghavan Committee had recommended to abolish the MRTP Act and to replace it with the Competition Act, and thus the Competition Commission of India was established. Now let's talk about the composition of the commission. It consists of the total 7 members. That means there is one chairperson and 6 members who shall be appointed by the central government. CCI acts as a quasi judicial body. That means it gives its opinion to statutory authority, and it also deals with the other cases related with the fair competition in the market. Now, what is the eligibility criteria to become the member of CCI? Basically, the chairperson and every other member who shall be the member of the CCI needs to have the ability, the integrity, and the standing to be qualified as a judge of the High Court. The one who has a special knowledge and the professional experience of not less than 15 years when it comes to the international trade, economics, business, commerce, law, finance, accountancy, and other matters. And those who are in opinion of the central government may be useful to the commission. The role and functions of the CCI. The first one is to eliminate any such practices which have adverse effect on the competition. So basically, CCI ensures the fair competition in the market, and any practice which leads to unfair competition or it leads to an undue advantage to any economic firm will be overseen by the Competition Commission of India. It also has the function to give opinion on the competitive issue if the reference is received from any statutory authority. It undertakes the competition advocacy. It seeks to protect consumer welfare. It ensures a fair and healthy competition. It implements the competition policies that the government of India make, and it also effectively carry out the competition advocacy. Now let's talk about the Competition Act of 2002. Now, this act was amended in the year 2007 and it functions on the following philosophy. The first is that prohibits any anti competitive agreements. That means it prevents the abuse of the dominant position. For example, bigger players like Google, Amazon, etc. So, any undue advantage taken by these big companies because of their dominant position in the market, any such agreement is formed because of the dominant position of in the market is prevented by the or is prohibited by the Competition Commission of India. And according to the Amendment Act of the Competition Commission of India, a tribunal has also been established in order to have a appeal against the order of the Competition Commission of India. And the government has replaced the appellate tribunal of the CCI in the year 2017 with the National Company Law Appellate Tribunal. Now let's move on to the fifth news of the day, and the fifth news is about the electoral bond. The government told the Supreme Court, we know that for a very long time, the electoral bond case is being pending in Supreme Court, and there was a question with respect to the transparency and accountability of the funding which is given in the electoral bonds. Therefore, the government in this context has told the Supreme Court that the electoral bond scheme is transparent. Therefore, this brings us to the electoral bond scheme. So there is a case in Supreme Court which has been pending with respect to the electoral bond regarding the transparency and the accountability of the funding received under the electoral bond scheme. So let's talk about the electoral bond scheme and its specificity. Basically, it's an instrument through which anyone can donate money to the political party. Anyone does not mean any foreign entity or any foreign establishment can also fund it through electoral bonds to the political parties. A citizen of India and a body established in India or a body inc in India will be eligible to buy the electoral bonds, not anyone. All right. Only the political parties. The second criteria is that the political parties who are registered under the Section 29A of the RP Act of 1951 and who has not secured less than 1% of the votes which are polled in the last general election to the House of the People or the Legislative Assembly of the state, they are eligible to receive the electoral bonds. So therefore, it brings us to the two important conditions to receive funding through electoral bonds. The first is the party has to be registered under the RPA Act of 1951, and the second point is that the poll performance. That means it must secure not less than 1% of the poll, either in the general election or the state legislative assembly election. Now, basically, the bonds, they are sold in the multiples of 1,000, 10,000, 1 lakh, and 10 lakh, and rupees 1 crore, which can be brought from the authorized branches of the State Bank of India either via check or a digital mechanism. Therefore, cash is not allowed so as to prevent the rerouting of the money. The donor can also give this bond to the parties of their choice, and the political parties can choose to encash such bonds within 15 days. And the electoral bonds can be brought only during the specific windows of time. That means they are not available throughout the year. So that's it for today. Have a nice day. Thank you.